Morning, everybody. Thank you for joining us this Friday morning. Thank you to the ARC for hosting us. It's our pleasure to be here. My name is Christian Escamilla, and I'm the head of our wealth management team at Broadway Bank. Many of you are Broadway customers. I've heard many stories of several of you banking with us for over 30, 40 years. We appreciate your relationship, and we appreciate the relationship that we've been provided with the community here. Barbara and Sylvia is typically who you work with on a daily basis. Unfortunately, they're both tied up this morning and couldn't join us, but they will be joining us for our Fiesta event that we're hosting in this room on May 2nd, I believe. Doing things a little differently this year, we're gonna have some San Antonio food favorites for Fiesta: chicken on a stick, quesadillas, of course, plenty of beer and wine. And I think we're going to try and get a couple of games of bingo or loteria going with prizes. And so we hope you can join us for that event. And we'll certainly get some marketing out so you're up to date on the details. This morning, it's my pleasure to introduce you to 4 people. First, I'm going to introduce you to a gentleman named Garrett Koss. Garrett, if you'll raise your hand. Garrett is one of our wealth advisors within our wealth management platform at Broadway Bank. Ernesto Aguilar was here. He may have stepped out for a second. Ernesto is one of our financial advisors with Broadway's. There's Ernesto over there, of course, on the phone with a client who's panicking about market volatility the last couple of days, no doubt. Yeah, we're getting a lot of that. Ernesto. And then, of course, we have our private banker that supports the ARC. Many of you have already met, she assists with bridge loans and financial planning and introduces you to other people on our team, Michelle Beza. And then if we have our 2 speakers this morning, and I'll introduce them in just a moment. Really quickly, a little bit about wealth management. When people hear wealth management, they typically think money management, asset management, investments. The fundamental difference between Broadway Bank's wealth management platform and some of our competitors, we're a fiduciary. And many of you likely know this. What that means is we have to academically and scientifically prove any recommendation we make for you is in your best interest. Best interest of your family, best interest of your estate plan, your legacy that we all leave behind one day. And the folks that I'm going to introduce you to this morning that are going to lead the presentation are also folks that are on our team. Both are attorneys, impeccably credentialed, and they handle the part of wealth management that not a lot of people think about. We do trust administration, we handle estate settlements, we deal with mineral management, real estate issues. And all of those folks are Texans based here in San Antonio, providing support to Texans. So thank you very much for your service to our country. Thanks for the invitation. And without further ado, I think first up is Monica Bonilla. And so Monica will be leading the conversation with another one of our Broadway bankers named Elizabeth Straight. So you'll get to hear from them both this morning.
Morning, everyone. So my name is Monica. I am a native San Antonian. And before I went to law school, I taught high school for 10 years. So I always want to see if there's any of my prior students around the room, because that has happened to me before. So, but welcome. So our goal today, Liz and I, we've been at Broadway for quite a while, working with clients who actually have appointed Broadway to be their executor in their estate, and also we manage trusts. So we'll talk a little bit more in detail about that, but my job today is just to go over some documents that we recommend that everybody has. And I'm presuming many of you have these documents already, so that's a good thing. But the information that we're going to discuss is based on current Texas law. This is what we're going to cover this morning. It's all listed out there. We're going to talk briefly about your last will and testament, powers of attorney, why they're so important, and how they should be used. We'll talk about, I get on my podium about a director to physician. We'll talk about that. And then Liz is going to talk about trust administration and different types of trusts. So take advantage of us, because we're here to answer any and all of those types of questions. So each of these things that you see up here, that is a separate legal document. You can have more than these documents, and sometimes people do have what's called a HIPAA release. Sometimes people also have a designation of guardian. We're not going to go into detail on those. These are what I recommend to our clients. This should be the minimum type of a legal estate plan that you should have. So let's talk about something super important. So if I were to be asked, oops, wrong way. When I'm meeting with a client, I kind of worry sometimes about whether or not they have legal capacity. So let's talk about what that means. To do any of your estate plan, you have to be, it's a legal definition, and it's capacity for legal purposes. And what that means is that you're able to understand and communicate with whoever is helping you with your estate plan. So everyone in this room, I can see you're making eye contact with me, you're definitely listening, which I appreciate, and you're taking notes. So I would say, unquestionably, even our bankers have legal capacity. So that is so important, because sometimes we may get a phone call from someone who says to us, like, I need to become a power of attorney over my mom and dad, well, especially my dad, because he's got advanced dementia, advanced Alzheimer's, he's 88 years old, and my brother and sister need to have a power of attorney over our dad. And I may have to explain to them that might not be possible. I understand what you say you need, but if your dad has advanced Alzheimer's or dementia or any kind of medical incapacity, he might not be able to have what's called legal capacity. So these first few documents, you have to have legal capacity. We're not medical, we don't have medical degrees or medical backgrounds, but sometimes it's questionable about whether or not someone has legal capacity. So the word of caution is that if you don't have these documents, you need to do them sooner rather than later, because things can happen to any of us at any time. So that's the first thing. Must have capacity to make these decisions. The first type of power of attorney I'm going to talk about is a medical power of attorney. So right now, all of us make our own medical decisions based on what our physician tells us about our diet, about what medication we need, about our exercise, about our health. We go to our physician, and the doctor and I make decisions together. There may come a point in time when something catastrophic happens, like a stroke or an illness, or even if you're going to have surgery and you're kind of incapacitated because of the anesthesia or the medication you're on. So a medical power of attorney is a legal document that you sign appointing someone to be your agent temporarily to make medical decisions for you if that need occurs. Once you recover from your operation or from your illness, you go back to making your own medical decisions. So when you appoint someone as your agent, you're not giving away your right to make those medical decisions. You just have someone that you're appointing that you trust to be your agent to make those medical decisions for you. If a doctor is saying to the family, your mom's going to have surgery, we need a medical power of attorney. If any of you have ever been hospitalized, it's pretty routine. And those of you that have medical backgrounds, you all know when we go to the hospital that they ask us if we have a medical power of attorney. Are there any questions on a medical power of attorney? This is a great legal document. It's drafted by itself. Again, you're choosing someone you trust that can make good, relevant medical decisions on your behalf, because for some reason you're unable to, at that point in time, you recover, you go back to making your own medical decisions. And I always advise your primary care physician should probably have this document. How many of you have one? Oh yeah, wonderful, wonderful, wonderful. Let's see, do the bankers have one? Okay, good, 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 good. Oh, the other thing I want to say in the very beginning, because we just did a presentation and this was one of the great questions we were asked, is that how long do these powers last? Well, all of these powers end at your death. And we're going to talk about something really that I want to alert you on, and it's called a statutory durable power of attorney. So this is a power that you're appointing someone to make financial decisions for you. Again, you're not giving away your authority or your power to make your own financial decisions. This is something that you sign. You need to appoint someone who is beyond reproach, completely trustworthy. Because back in, Liz and I were talking about it, and I can't remember what year it was, but a few years ago, the legislature here in Texas really broadened the statutory durable power of attorney. And it has a lot of powers that it didn't used to have. So this, unfortunately, is a tool that people that are not trustworthy have taken advantage, and there's been an enormous amount of financial exploitation on this document because they are able to actually now change your beneficiary on your bank account if they have this legal document. So people have to be really aware. People always want to choose family members, and I say that's fine, but don't pick someone that you frequently give loans to, because they might have an issue and they might not be able to manage your money. So I'm pretty blunt with people. They'll say they want their son, and then I ask questions. Well, tell me about your son. Does he have a job? What does he do for a living? And oh no, he's declared bankruptcy 5 times and he's a spendthrift. And I'm like, I don't know if he's the most appropriate person. And then I start telling them, let's look at the powers. Too often we sign documents in our life without really looking at all the fine print. So this is a document that I urge you just to be very cautious about it. All the powers on this document are listed out, and some of them are what we call hot powers, because you're giving someone, they could even terminate a trust. I mean, there's so many things that are listed out as far as powers. If there's one power that makes you nervous or anxious about, cross it out and initial it, and then that's going to be one power that they're not going to have. But definitely, it's a vital decision to find someone trustworthy that's beyond reproach. And unfortunately, there's a lot of us who have many stories, and working in a bank, I can tell you that we're very cautious when someone brings in a power of attorney, because we want to make sure that this is something, it's definitely needed, but that the person who's bringing it in, do they have something financially to gain by having this? I mean, there's a lot of people in San Antonio who choose caregivers, and for me, that's always a red flag. That is absolutely a red flag if it's someone who's not a relative, who doesn't have a financial background, and they have this power. So they're pretty broad and sweeping. The other thing to remember, and family members often don't know this, but this power of attorney ends at your death, okay? So the agent you choose to have this authority, they're not supposed to continue using this authority after you die. And a lot of people don't know that. So we have people that call and their parent or their loved one is deceased, and we have to tell them, no, you don't have authority to go into their bank account anymore. Or no, I really can't speak to you about their wealth management account because your authority ended at their death, and they're shocked. But that's really important for you to know that whoever you've appointed to be your agent for this financial power of attorney and the medical one that I already spoke about, when you die, their authority ends. And then we'll talk about what we look at next, which is going to be your estate plan, your will. Because then now it's your administrator or your executor that has the legal responsibility and the power to make decisions on your behalf after you die. So a lot of people don't know that, and that's something I wanted to bring up. Are there any questions? Because I know some of you have stories about people that have been exploited. Yes, ma'am.
I was reading an article, and it talked about a person had a power of attorney, but this bank or that financial institution or stock account wouldn't accept it. They had their own power of attorney that they wanted used. So
I'll let Monica answer it,
Okay.
but let me repeat the question. We'll get a microphone for the next person who asks a question. The question was, what happens if you go to a financial institution and they state that they don't accept your power of attorney? They want you to complete their form of a power of attorney.
That is not unusual, unfortunately. So if you go to a bank like Broadway or Frost or even Jefferson, those are banks that are familiar and they will accept this type of power of attorney that you have that was drafted in Texas. I've seen clients that have difficulty with the national banks, the ones that are all over, that they do require you to use theirs. And that is legal. They have that in their compliance rules. That is what they can do to you, unfortunately. So it just depends. My answer is that does happen. So it's kind of unfortunate.
It is more common with national banks that operate in many states. Sometimes that's because the rules in Texas are very different than that of California, as many of you know. And if the bank is conducting business out of California, that's their primary charter initially, and then they are nationally chartered. That might be why they're asking you to complete their form. I would tell you, if something doesn't feel right, consult your legal counsel. And if something, as you know, if something doesn't seem right, don't sign it, don't agree to it.
Thank you. So the next document I'm going to talk about, and I'm really going to date myself when I talk about this one, is the directive to physician. So how many of you in this room remember a very famous case, and it involved a woman from Florida called Terry Schiavo? Once I talk about her, y'all are gonna start to remember. So the background of Terry Schiavo, she was a young woman. This was in Florida. And in 1990, at the young age of 25, she actually suffered a significant cardiac arrest. And she was successfully resuscitated, but she had massive brain damage due to lack of oxygen to her brain, and she was actually left comatose. Ultimately, Terry was diagnosed as being in an irreversible, persistent vegetative state. Terry was married, and her husband had to go to court, and he became her legal guardian. He was her next of kin since she was married, because he wanted to have Terry's, she was artificially being kept alive in his mind, and he wanted to have her allowed to die as gently and comfortably as possible. Terry's parents did not agree with their son-in-law, and there was actually a big court battle. It went to the Supreme Court. Long story short, no one really knew what Terry would have wanted, because she did not have what was called in Florida, they call it a living will, but it's the same thing as a directive to physician. In Texas, we don't use that term, living will. We use directive to physician. A lot of states use directive to physician. Florida uses living will, and if you grew up somewhere else or live somewhere else, some of you may have heard it called a living will. But this is the document we're talking about. So Terry eventually died when her feeding tube was removed, but the main purpose of a directive is to provide instructions on whether or not to withhold or withdraw life-sustaining treatment only if you fall into the category that you have been diagnosed with a terminal or an irreversible condition. That's the only time this applies. So it's a medical finding that you have this disease, it's terminal, or you have this disease, it's irreversible, eventually it's going to become terminal, and while we are alive, we get to make that decision whether or not we want to be put on life support, what kind of life support, or whether or not we want to be allowed to die as gently and as comfortably as possible. This is such an important document because there are so many family stories that I have and have experienced as an attorney where the family doesn't agree on what to do. When My mother, for example, case in point, had a catastrophic stroke, and she has a daughter who's an attorney, but she did not have these documents. Because my mother used to tell me, Mija, the day you make me sign these documents, that's when a bad thing's gonna happen to me. I could never convince my mother to sign anything. So my sister and I were in agreement with what the doctor was telling us, and we felt we knew what my mother wanted. My brother totally disagreed with us. So at a time when my sister and my brother and I should have been comforting each other, loving each other, supportive of each other, there was so much tension within the three of us because no one could say, this is what mom wanted and here it's in writing. The good news is that my mom eventually recovered, and as soon as she had capacity, I was like, I brought in an attorney to meet with her. I didn't do it myself because I didn't want anybody to accuse me of putting duress on her or influence her, and she signed the documents. Many, many, many years later, my mom had another stroke, and luckily these documents were there, and my brother was fine because he knew that what my mother wanted. Yes, sir. It depends on the state, but we have honored, Texas will honor ones from other states, so it's those darn lawyers. They make people in every state, there's a little nuance. Some things are different, some things are changed, but if you live in Texas and you're traveling, this is gonna be honored. You don't have to be actually here for this to be honored. And I'll talk at the end about why I really encourage you, if you feel like Texas is gonna be your home state, you're not gonna move, I'm not talking about traveling, I really would encourage you to have Texas documents. But yes, it should be honored anywhere. Yes.
Does it have to be certified?
I have when you say certified, are you talking about notarized?
Yeah.
So the directive has to have 2 witnesses sign and a notary. So there's actually 3 people involved. You sign it, 2 witnesses, and a notary.
Okay, what if there's not time to do that? I just had a friend who was diagnosed with terminal cancer
Okay,
and going into treatment,
Okay.
and she wanted to have this done before she started treatment the
Sure.
next day. And, we had her sign it and witness it, but there was no notary or anything. But as long as we had the witnesses and her signature, shouldn't it be okay?
well, it's supposed to be notarized for legal purposes, it's supposed to be notarized, but I'm sure if she's able to communicate, she can make those decisions herself, anytime. You can verbally instruct your physician as to what you want, as long as you're able to. So that's one good thing. All these documents are good, but if you're able, these documents are important when you're not able to communicate your needs or your desires. So as long as she can communicate, she should be in good shape. Okay, great question. This one, so I work with a lot of family members after their loved one passes away that have appointed Broadway Bank to be their executor of their estate. And now I start talking about this document because I have actually had multiple accounts where we don't know what this person wanted after their death in reference to, do they want a funeral? Do they want to be cremated? What kind of a service do they want? So I talk about people. This is a document called Disposition of Remains, and in Texas, you can sign it and it's very clear. Funeral homes want this document, especially if you're going to be cremated. They want this document from you. So it's important that you think about it. It's a simple document. I actually put on if you Google that last Texas Health and Safety Code, the form will pop up and you can print it out and sign it and put it with your estate plan if you don't have this document yet. So don't assume that you don't need it. Okay, so this is important because we have had some issues with family debating about a casket versus a cremation. So that has become more and more important lately. Yes, ma'am.
If you already have a paid pre-planned funeral, does that count?
So that's a great question. The question is, what about a prepaid funeral plan, which is another very important task or that we should think about. the funeral home should have your written instructions, and that's fine. This is when there are no written instructions anywhere about what you want.
Now, a lot of us have Neptune, so we haven't gone to a specific
Okay.
funeral home.
Neptune is a great, we have a lot of clients that use Neptune Society, so what their it's a company nationwide, and I don't even know, they might even be worldwide for all I know, but a lot of our clients use Neptune Society, and it's a very good organization that will have you cremated and your ashes are delivered to whoever you've authorized to have that. So all these things are important, and we've dealt with Neptune many, many times, and they are a very good organization, very respectful. I can't say anything but good things about that. Yes, ma'am. Great question. Okay, this is my last slide. Oh, yes, sir. The question is, and I do have people that put these instructions in their will. Let's talk about it right now, because I think the will is different, because one, the will has to be probated. So even though it's in your will is not really valid until someone takes it to court and is admitted as a legal valid document. So that to me is a hang-up. That's an issue, because this other document I'm talking about, if it's there, we don't want to wait 2 months to go to court, because it's not that quick to get to court, right? So you want this disposition of remains, because then whoever is in your family, whoever you've appointed to do this, can take action immediately. The last will is a totally different type of document. So, did y'all understand why I'm emphasizing this? Okay, let's talk about your last will and testament. So, in Texas, not in this room, but probably about 90% of people die without a will in Texas. And that's because they don't think they have an estate. Or they say, oh, I only have a house. I don't have an estate. You use the word estate, and I don't know what they're imagining. What's that show in England that we all saw for so many years? You know, an estate. They're thinking this, you have to have a lot of money. But no, I encourage everyone over the age of 18 to just have a simple will. Because if you die without a will, you probably have a car, you probably have bank accounts, and many people have real estate. You have an estate. If you die without a will, someone still has to go to court, and it's cumbersome, it's expensive, it takes a long time, and be appointed as your administrator. And there'll have to be an heirship determination, because without a will, the court doesn't know what you wanted to do, who you wanted your stuff to go to. So the court will make that determination based on who your blood relatives are. So we have accounts where people have died without a will, and it takes us years to get that wrapped up. We have an account right now where we have already found over 80 heirs. This gentleman who passed away had no siblings. His mom and dad were only children. They had been gone for decades, because this gentleman was in his 80s. He never did a will. So we have had to go back up. His parents had no siblings, so he had no cousins. He had no aunts and uncles. We had to go to the great-grandparents, who of course were born in the 1800s. So imagine all these people we're tracking down. They have no idea who this gentleman is that passed away. And he died with over $2 million. So all this money, it's taken us 3 or 4 years to figure out who's gonna get it. Because we have to go up through the mom's side and the dad's side. And then we have to find these living relatives. So that's a reason to have a will. Because I wish he would have just left everything to charity. Any charity, because he belonged to a church, and I just wish someone would have said to him, just leave it to charity. But so I tell people, please, you must have a will. Otherwise, it just gets so complicated. Any questions about that?
Hey, Monica, before you move on, can you share with how Broadway can assist with estate settlement services?
Sure.
And what you do every day?
So my job and this is what I've been doing for 11 years at Broadway, is we have many clients who appoint Broadway or name Broadway in their document as their executor. I always tell couples, appoint yourself, appoint your spouse as the executor, and then have a backup. And very often Broadway Bank is the backup. And very often I meet with a surviving spouse, but they're 95 years old and their husband's just passed away. They don't want to do it or have the desire or the willingness or energy to do it. So then we get to step in as a successor executor, and we take care of the heavy lifting. We make sure taxes are paid, assets are gathered, creditors are taken care of, and then we distribute the assets pursuant to the will. So that's a job that we do very well. We have a great team that works. If you pass away with real estate, we'll look and see what you wanted to have happen. We handle real estate all over the country. So people have real estate in Mexico, people have real estate or timeshares or whatever it is that you have. We have the expertise to liquidate it or transfer it to a relative if that's what you wanted. We're very efficient. You can ask Garrett at the end, if you have specific questions about the fee or anything, he'll be here. So we actually have a lot of clients from where y'all live that we're named in their document to be their executor, because it's a thankless job. Can I tell you that? I get paid for doing it, so there you go. Most relatives don't get paid for doing it, or most relatives don't have the time or the effort. My son is a physician. I used to have him in the document until I got this job, and then I realized I can't do that to him. He works, he's got a young family, so Broadway is gonna be our executor, my husband's and mine executor. My daughter lives in Rhode Island, so how's she gonna help? So you want somebody local if this is where you decide you think you're gonna live until you die. It's something to consider. Yes, sir.
Most of them we can obtain, or a lot of us have obtained them from either Fort Sam or Randolph. Are they acceptable within the San Antonio legal community?
Definitely, as long as it's a very simple, uncomplicated will. Yes, we do. The JAG office does a very, very decent job. One thing I want to notice though, with a lot of those clients, or a lot of those documents that I've seen is a problem. And it's not so much with the will, it's with the other documents that the JAG office might have done, like the powers of attorney. Because very often they put an expiration date. I don't know why they do it. I've actually called the JAG offices and encouraged them not to do that. They'll put an expiration date. So a lot of active duty service men and women go to the JAG office before they leave our country to go serve, and they get these documents signed there because they're told to do this before they leave and they're active duty. And for whatever reason, they'll say, well, how long are you gonna be gone? And they'll put like an 18-month or whatever 6-month expiration date. That has been a huge problem, because if something happens to them, if they have any kind of an injury, their loved one who they appointed, if that date comes into play, they no longer have authority to make medical or financial decisions for them. So I haven't had problems with the wills from those offices. I've had problems, big problems, with the other documents, because you shouldn't have an expiration date, and they won't agree with me, and I argue with them because we've ended up having to go get a guardianship, and that's very costly just for that family member to continue making financial or medical decisions for their young son who's coming back injured. Especially, so this is a true story. I have all these experiences of like, why would they have put an expiration date on it? So they still do it, and I don't understand why. So look at your documents. If there's an expiration date on it, it might not be valid anymore.
We have a question over here.
What happens if your will is from out of state?
So it depends. We would have to look at it. We would have to look at it, because if it conforms to most of Texas law, it should be fine. But without looking at it, I can't say yes or no, just automatically. So we have people that could look at that for you if you would like. One more minute, because I gotta get off so Liz can talk. Yes, ma'am.
We got another one.
How do you get notified, if you're the executor, how do you get notified we're dead?
Well, that's a great question. So How does the Broadway Bank get notified, or how do you get notified? Okay, well, I know. So what we hope has happened, we have a lot of what we call future appointments, and we try to meet with you while you're alive, right? We try to meet with you once a year while you are alive, and you have all of our information, and we encourage you to let where you live. The ARC calls us all the time because they know here that we're named. So they call us, or a family member, or a friend, or your neighbor. They have our card, and if you pass away, we usually get a call pretty quickly.
We also scour the obituaries.
He's right. We do look at obituaries, and if your name pops up, we do check, because we have a master list. Okay.
We've got one more, we got a question over here.
Okay.
Not to worry, I will notify Broadway Bank.
Okay, I have a question.
Yes, sir.
Since the executor job is a thankless job and uncompensated, is it prudent to, in your will, to leave a percentage of your estate to the executor? Is that something that would be acceptable to?
It's up to you. It is, so an executor can request that they're reimbursed for their out-of-pocket expenses. Because there will be a court filing fee, there will be your CPA will have to be involved to file your tax returns. IRS still has to be paid. So we still have, they're automatically under the law, they will be reimbursed for out-of-pocket expenses. And if you want to leave them a certain amount, that is totally up to you.
Here's what we ask you consider. I've been in the industry for 26 years. I have seen last wills and testaments leave a percentage to their grandson, who's going to be the executor of the estate. Not only is it a thankless job, it is a tedious job full of drama. Imagine you're a grandson, and they have 4 or 5 siblings and cousins. People become to resent the executor of the estate because they believe they're making the decisions and they control the documents. I personally, when my grandmother died, saw an uncle who was in his late 50s, who's passed on now, so I can tell the story. He lost it at my aunts and uncles and at my mother because he received $2,000 less than everyone else. And he alienated himself from the family for over a decade until his death over that. And so what we ask our clients to consider is meet with Garrett, gentleman over there in the tie, talk to any of us after, set an appointment with us. We'll review your documents and we can talk to you about what the estate settlement services team looks like at Broadway and how we may add peace of mind, not only for you, but for your family, and protect the family structure. Because you see crazy things happen over a piece of art, over a statuette, over a Porsche. These things happen pretty frequently.
Well, this is great what Christian just said, because I need to talk to you about personal property. That is the hardest part of my job. So I tell people, you can't take it with you, okay? You cannot take your personal property with you. And that has been the interesting part of any estate, even the ones that have named Broadway, where we don't have clear instructions about what to do with your personal property. So I tell people, while you're alive, I tell all my relatives, if that ring doesn't fit you anymore, sell it or give it away. If your necklaces, get too tight around your neck, get rid of it. Get rid of your hummels. Hummels, there's too many humps. The value has just gone down so much. Guns are still a good buy, okay? Guns in Texas will always be valuable, but there's a lot of things that people have collected, all those German beer steins. Start giving them away because they're not priceless. They're not. And so things that are sentimental, your Bible, things that are important to you, you need to tell somebody who it should go to. Because I've had a lot of family dramatics, even though we have ways of doing it. If we don't have instruction, we just have ways of doing it that you might not like. So it's real important that you let us know about your personal property. And that being said, yes, ma'am.
One more question.
Can a will ever go out of date after so many years?
Absolutely not. We even have what's called holographic wills, which you don't recommend doing a holographic will, but there's wills from the 1900s that we accept. The court will accept it. Yes. Yes. So you need my recommendation, my last one is looking at a trusted professional. I've had some very intelligent retired military people that are so smart, but they insist on doing their own will off the internet. And they get really irritated with me when I go over it with them and I start, this is not gonna work, this is not gonna work. And they're adamant about this. And I tell them, you have to use a trusted professional, because there's little nuances and there's things that you may not even be thinking about, but we can prod you and ask you questions about things you haven't thought about, just based on our experience. Well, I am going to introduce my good friend and colleague, Liz.
Good morning, everybody. I'm Elizabeth Strait, or Liz. Liz works. And I like Monica's slides, and the last comment there kind of falls into what she was just saying about, and I like this one, be wary of anyone offering to buy you dinner to tell you how to avoid probate. And I just want to reiterate that using a trusted professional to draft any kind of estate planning, is it short? Yeah. Okay, gotta be smarter than the microphone. Thank you, Christian. I lost my train of thought, but anyway, anybody who offers to buy you dinner, use a trusted professional. It's great to go to those kinds of events and sit and listen, and maybe you'll learn something new, but when it comes down to drafting documents, I really believe you want an attorney doing that for you. And so my first slide is, what is a trust and do I need one? And first of all, a trust is a legal document that allows a person to control how and when their assets are distributed after they pass away. It's a fiduciary relationship between the grantor, the trustee, and the beneficiary. And as Christian said, a fiduciary relationship, I think we're all pretty familiar with that term now, is somebody who must act in your best interest, you, the creator of the document, as opposed to their best interest. And so yes, you want to appoint somebody as your trustee who you know understands what that means and is capable of doing that. And so in its simplest terms, because people ask, what is a trust? In the way that I was first taught, the concept was it's basically a bank account with written instructions. And so I often have people ask me, can my document say this? Can it say that? Within reason, it can say anything you want it to be. And where we often come into play is when people have a question about, how can I say this? Not so much legal questions. Monica and I happen to be attorneys, but that's not our job at the bank to be practicing law. Our job is to administer trusts. And so we are often looking at documents from the perspective of, is it appropriate? Is it reasonable to expect that what this document says can easily be carried out? And I have an example of a situation I ran into recently where I was reading a document and it said, that all of the personal property, and personal property always seems to be the problem, it cannot be sold. It must be distributed to this person's children, and if it has to be shipped to them somewhere, that they have to pay for it. And so your document, it can say that, but logistically, is that, I was like, I would recommend you change that and allow it to be sold. And I often see documents where shipping costs are covered by the assets in the trust or the estate, which I think is great. And so then the next question is, do I need a trust? Well, it depends. Typically, I would say it depends on the circumstances of your life. And that is, you have something like an ongoing business. Do you have tax considerations? And right now, I believe the exemption is $13.9 million in 2025 before you have to worry about estate tax. So the vast majority of people I talk to nowadays don't have to worry about estate tax. So then the next question is, do you have somebody in your family, a child, or somebody who's going to inherit? I had a client who had a niece who has special needs, and they're on some type of Government benefit through Medicaid or Social Security. There's trust planning around that needs to take place. And then the next one would be, are you trying to avoid probate? And I will say in Texas, probate is a pretty easy and efficient, and easy and efficient, and I was gonna say, and relatively inexpensive process. So going through probate in Texas isn't a bad thing, but where I've seen trusts really benefit people is if you have a couple who they have children and they're really far away. And so, you're here in San Antonio and the children are in Seattle. And it's not that there's a strained relationship or anything, it's just they're not close by. And trusts are very beneficial when it's no longer about, you're either alive or you've passed away. It's that period in between where you're incapacitated. And having a trustee be able to step in very easily, who's named in a document, and just, boom, rock and roll, it had some type of catastrophic event, and you are no longer able to easily take care of your business dealings as you would day to day, then you have this person named in the document as the trustee who can jump in to that role. And it's just hard sometimes when that person's really far away. And so that's where I've seen a bank or a corporate fiduciary be able to step in and take on that role and carry out business and pay your bills. And if there are assets in checking accounts outside of the trust, pull them in. And that's often done with a power of attorney. And that's something that we sometimes have clients, they'll name us not only as a successor executor or trustee, but also a successor in their statutory durable power of attorney to give us the ability to gather the assets, get them into trust. And so that person, as they're recovering their health, can be focused on that, and we can focus on making sure that the business of their life moves forward. And so that often happens through something called a revocable trust, and y'all are probably familiar with that. A lot of you may even have one, and that's where you have initially the creator of the trust, the grantor, is the trustee, the grantor, and the beneficiary for a period of time. And then as time goes by, if they decide, I don't want to manage the business of my life anymore and I'm looking for somebody else to do that, then you can have the trustee step in, and that may be another individual, and you may have a child or a friend close by who is great with managing assets, and you can say, come on in and start taking on this role. But often, as I mentioned before, you've got somebody who's far away, or I run into a lot of people who they've named a friend and they're saying, oh, my friend is older than I am and they don't want to manage this. And that's where often a corporate fiduciary can come in and be of value. He was just asking me to expand on a revocable living trust. So revocable trust allows the grantor, the person creating the trust, to change or terminate the trust at any time, while an irrevocable trust is considered permanent and cannot be easily modified once established, meaning the grantor gives up control over the assets placed within it. Essentially, the key difference lies in the level of flexibility and control the grantor retains over the assets. So most people that I work with, they start with a revocable trust. And they're the ones managing the assets in the trust, and they're the ones that do a lot of the gathering of the assets into the trust. And then over time, if their capacity changes, they often come to us and tell us, we've worked with you for a while, Broadway Bank, we trust you, we're comfortable with you, would you start acting as the trustee? And we'll sign a little document and make that happen. They'll sign it as well. And then over time, that trust could become irrevocable depending on the language in the document. But there are also trusts, and when I was talking about tax planning, that start out irrevocable. And so that is a different circumstance where you are trying to get the assets out of your name for liability purposes, or as I was talking about, a special needs trust. Those are irrevocable. They may start and they may be created in a revocable trust document or a will, but they are intended to be irrevocable for the purposes of that beneficiary. But if you're just trying to gather some assets that you have and avoid probate, a revocable living trust is a great place to start. Any other questions? Oh, yes, sir.
Can you address briefly a standby trust?
So a standby trust is a part of a tax planning concept. And so that's when you have like an A and a B trust type of situation, and that's more kind of a complex tool for tax planning. Oh, you're talking about like standby, like you've created it and we have it basically, it's on our books and it's not activated. Oh, I see what you're talking about. I was thinking of something else, but yes. So we have that too, where people draft them and they name us, and we kind of treat that as a future appointment where we're in the document and we're just waiting for somebody to tell us.
So it's basically a contingency trust?
Yes, sir. Yes, sir. Okay, any other questions? So trust planning. The first question I would ask myself is, do I have a unique situation, an ongoing business, adult children who are spendthrifts? Am I worried about tax considerations, a special needs child? Am I trying to avoid probate? And a revocable living trust is a valid tool if the circumstances warrant. And of course, if you have unique assets such as oil and gas, farm and ranch land, or any kind of real estate outside of Texas. And so you may ask, you know, Broadway Bank, you're here, why would I want a bank to be my trustee? And I say that because a corporate fiduciary offers professional expertise, objectivity, and continuity. And as Monica was mentioning earlier with some of the other documents, it helps when there are complex family situations where personal biases might arise. And a corporate trustee is not influenced by personal relationships or emotions. So, you know, if there was an argument at Thanksgiving last year, we weren't there, we're not a part of it, we don't have a side, we don't have any skin in the game. So then the next is access to specialized financial resources that an individual trustee may not have. And we're not talking, as we've mentioned previously, just financial assets, but oil and gas, farm and ranch, real estate, dealing with someone's home. And then the legal and regulatory oversight. And I've had somebody ask me before, well, you know, how do I know that a bank is going to do what they're supposed to do? And it is because of the legal and regulatory oversight, and we're audited internally and externally every year, externally and multiple times a year internally. So we can't just do what we want. And so I would now welcome any questions that y'all may have for any of us. Yes, sir.
How do you avoid probate?
So you avoid probate by getting your assets into a trust. Typically, that's the way to do it. Or just not having any assets at all, but I think that's pretty unlikely. Yeah, but yes, sir. It's creating a trust with a trusted attorney and then getting those assets into the trust.
There was a question over here, I believe. Somebody? Oh, right here, sir.
How much does it cost for the bank to be my trustee?
So that is a question for Mr. Garrett Cost.
Can we go ahead and talk about it? It's okay. We can talk
Okay.
about our fee structure.
So typically we start at 3% of the assets. After we've gathered everything and we've inventoried it, that's our fee. And depending on the side, it scales down from there. And Monica, do you know what the next tier is?
3% on a year, per year, or what?
The whole estate.
So that's to serve as for the bank to serve as the executor of your estate is 3% of the market value of all the assets, and then it goes.
As of your date of death, for your probate assets, it's 3%. But it's different for trust.
Yes.
Is that a one-time charge?
Yes.
Yes, for the estate settlement services, it is a one-time charge. You want to talk about our trust fees, and just to make sure we're on the same page, when the bank serves as a corporate trustee, we're making decisions on your behalf based on the document itself, and in some cases, making distributions to your beneficiaries. It could be yourself as a beneficiary of the trust, depending on the type of trust, right? And you've got this oversight of a team of people. So what you see before you are 3 or 4 of us representing wealth management. We actually have 70 people in San Antonio and a handful of people in Austin. Soon we'll have a handful of people in Dallas and Houston as well. And This group of impeccably credentialed people meet on a weekly basis or as needed. And what we do as a group is we talk about, here's Mr. and Mrs. Smith's trust. These are the provisions of the trust. Here's the requests that are being made. Is this within legal parameters, regulatory parameters? Does this distribution, does this request meet the purpose of the trust? Now, when we're handling an estate, it's a little different. Monica and her team are sitting and reading the estate planning documents and making sure that we are living and breathing by what you told us you want to happen. And so the estate settlement fee, has already been discussed, starts at 3 and goes down. Do you want to talk about our trust fee?
Yeah, and our trust fee schedule for a revocable trust, which includes the management of the money, and we typically do some bill pay there for a lot of our clients as time goes by. That starts at 1.25%. And then once a trust becomes irrevocable, there's a different fee schedule for that, because then we're no longer taking direction from the person who created the trust, because typically we start out, we work with the grantor, and if money is needed, you just call and say, Liz, send me, $50,000, I'm gonna buy a Cadillac. And I just say, yes ma'am, or yes sir. But as time goes by, if it becomes irrevocable because of capacity issues or what have you, or somebody passing away, then we have to get our trust committee involved in making decisions around making distributions, and there's more work that goes into that. So then you're at a 1.4% fee schedule.
And I will say that's the starting point, right? Every relationship is different. We certainly won't go higher than that, but there are instances where you may have a very complex need, and we were able to make some concessions. Question in the back.
Can you talk a little bit about probate assets and what a probate asset is? Because a person could die having $1 million in assets, but not one of them would be a probate asset because of how it's titled, joint ownership, payable on death accounts, beneficiary designations, things like that.
Yeah, so those are all non-probate assets. And that's another way to avoid probate, is to use those type of designations and get those assets outside of your estate. So basically, anything that you haven't contractually, through some type of beneficiary designation, or decided where it's gonna go, or to whom it's going to go, or you haven't put into your trust, meaning changing the title to the name of your trust, then that is a probate asset. And that's why even if you have a great trust document, your attorney's always gonna draft just maybe even a little 10-pager will, to make sure that if there's something out there that you forgot about, that there's a way to get it to the proper beneficiary. And so you'll be stuck with having to do probate. Potentially, there's some ways to avoid that, but it's a safeguard. Any other questions?
Any other questions? So let me summarize a couple of key points. If you're sitting there wondering, is my estate plan in order? Do I need a trust? Remember that we have a couple of incredible folks here supporting the ARC. Many of you know Barbara and Sylvia. Barbara and Sylvia can get you in touch with Michelle Beza, who's on screen, and Garrett Koss. And we'd be more than happy to sit down with you, review your documents. What we'll do is take a copy, we'll bring them back to our team, we'll huddle, have a conversation regarding the conversation you have with Garrett and Michelle, and then we'll come back and provide some feedback. Now, we do not provide legal or tax advice, but we can give you some talking points to take back to your estate planning attorney or CPA. And if you need a recommendation for one, we're happy to refer you to several in and around our community as well. And the goal is to introduce you to our platform. All of our advice and guidance is free. We don't charge a fee for that. For those of you who are interested in financial planning, cash flow modeling, if you want to see what does my estate look like today, we use cutting edge technology at Broadway Bank, where we're able to provide you a estate plan flow chart that shows, based on your asset structure today, this is the amount of taxation, if any, that your heirs are going to have to pay after your demise, as based on the way your estate plan is structured today. And then we can provide you with an alternative, right, for you to meet with your attorney about. And so, in short, if we can be of help, please know this doesn't have to be a stressful situation. Most of you sounds like you already have your estate plans in place. We're happy to meet with you, review them, and then just share our perspective. Any final questions before we get wrapped up?
Yes, if you had your documents prepared, let's say 7 years ago, should you have them updated? Should you have them reviewed by the staff judge advocate folks, and that sort of thing?
I kind of say the rule of thumb is every 5 years or so, just look at them. And, you know, if you have somebody at the JAG office that you can say, hey, can I schedule a time to come in and review these and chat with you and make sure everything's still good, I highly recommend doing that. It can't hurt.
Okay, so with all this, do you folks come over here to the Ark to meet with people, or do say, when I need to go downtown,
No.
or over to the branch over on Nacogdoches, or?
We come here and we have a financial center here in the building, and then in the building next door actually. But also I have some clients that have been Broadway Bank clients for a long time, and I come here. In fact, I have a stack of tax documents that I'm going to be delivering today after we do this. So yeah, we come here. Michelle and Gary.
Sir, my name is Robin Bosch, and I oversee the ARC where Barbara Williams and Sylvia Laura works at. So if at any point in time, if you want to meet with any of our specialists, just let them know and they'll schedule an appointment for you.
And we'll come to you.
And we will come to you, okay?
Yeah, and can you talk about the hours that we have today?
And since I have the mic, so I will let you know that I let Debbie know today that as of the 25th, we're going to extend our hours at the ARC. So yes, so we're really excited. So Tuesdays and Fridays, they will now be 9 to 4, beginning the 25th. Yes, so we're very excited about that.